Good morning. This is Nick Augustine here with attorney Joseph Wrobel from Joseph Wrobel Limited, the Chicago Bankruptcy Law Firm. This is the Chicago Bankruptcy Update podcast featuring information, news, and updates in bankruptcy law. Financial troubles are stressful, and bankruptcy can be a solution for you. If you're considering filing bankruptcy, Joseph Wrobel will courteously and professionally review your finances, answer all your questions, and provide you the information you need to allow yourself to decide if bankruptcy makes sense, has value, and is the best way to provide relief from your financial woes. For a library of information about bankruptcy and the Chicago Bankruptcy firm of Joseph Wrobel Limited, please visit the website at chicagobankruptcy.com. This bankruptcy podcast covers several topics from real people with real questions, and Joe does his best to give the best answer. A sampling of some of our topics today will be: can a tenant use bankruptcy to avoid eviction? Can I stop a wage garnishment with no income? How can I protect myself from foreclosure with bankruptcy? How can I keep my car if I have to file for bankruptcy? When can I purchase a home after a Chapter 13? And how much do I have to pay in a bankruptcy? Those are a few of our sample questions. Again, I'm here with attorney Joseph Wrobel. He's been practicing attorney since 1973 and has experience in a wide variety of legal matters relating to individuals and their families. He presently concentrates his practice on consumer bankruptcy, where Joe Wrobel helps clients get out of debt and get a fresh financial start. He is an active member of several bar associations and is on the bankruptcy panel of the Pro Bono program of the Chicago Volunteer Legal Services. Joe Wrobel earned his BA in psychology from Northwestern University, and in 1973 he earned a JD from DePaul University Law School. He also served in the U.S. Army Reserve 363rd Civil Affairs Unit. All right, it is time to get rolling today on our program. Joe, how are you this morning?
I'm doing fine. Can we test? Can you hear me okay?
Yes, sir, I can.
Okay, great. I put on some headphones, and I want to make sure this technology is working. So, ready to go for the first question.
All right. The first individual says that they were served with court papers by a bank on a credit card they owed money for. They said the court date is in December. So they live in California, and the homestead exemption there changes on January 1st of 2021. The person says that they need to file their bankruptcy, but having the larger homestead exemption would be beneficial. Can they wait to file it? And if so, what happens with the court date?
I think first I want to talk about exemptions. One of the concerns that almost every single client has when they come and talk to me about bankruptcy is, what happens to my house, my car, my furniture? Can I keep it? Do I lose it? So every state has their own procedure with regard to exemptions, meaning what can you exempt from the bankruptcy estate, from what the trustee can take from you. So a homestead exemption allows you to keep a home depending upon the value, what you could sell it for, in relation to your mortgage balance. This varies from state to state, and I'm aware that in the state of California, it's going to increase to a much bigger number in January. I don't know the value of this person's house, but obviously he or she has done some mathematics and figured out that if they can file after January 1st, they can do a Chapter 7, get rid of their debts, and keep their home. So then the question is, can they wait that long? Most court matters, when they're up the first time, especially when you're being sued for money on a credit card, and particularly in large urban areas, it's not that difficult to get the case continued the very first time. That may be different in small rural areas where the court docket isn't backed up very much. But my experience and from talking with others, is that it's not that hard to get it continued. And if this is coming up in December, January 1st isn't that far away. So in this particular case, they would appear in court or perhaps hire an attorney, get the matter continued, then they can file after the 1st in January. But let's say they can't. Let's say a judgment is entered against them in December. So a judgment is a determination by a judge that money is in fact due and owing, excuse me, and it allows the creditor, the credit card company, to collect from the debtor any way that's legal, which is usually a garnishment or a bank freeze. But this usually doesn't happen immediately. It takes a few weeks for the process to go through. It depends how fast the credit card company and their attorney moves. So if there would be a judgment entered in December, most likely there is not going to be a problem waiting till the 1st of January. So their concerns, they should be fine because of the timing.
All right. Well, good to know, and we wish them the best of luck. On to our next set of individuals. And this one is a rental situation. It's a nervous thing right now with everything going on with COVID, when people are losing jobs and losing homes. And the tenant situation is stressful for the tenant as well as the person who owns the rent house, or apartment building. So anyways, this person is the owner, and when they say, if my tenant, apparently there sounds like the tenant's going to file for bankruptcy. It says, if my tenant files for bankruptcy after already having received my written notice, can he temporarily avoid the eviction?
Well, forgetting about COVID for a second, when a bankruptcy is filed, all collection, all activity, all lawsuits against the debtor stop immediately, actually at the moment in time when the case is filed. Even the IRS is stayed or stopped. If they are garnishing someone's wages, which they can do without having to go to court. So the filing of the bankruptcy itself is very, very powerful and gives a lot of relief to debtors. Now, in this particular case, if there's an eviction ongoing, then that eviction will stop. The landlord will have to go back, will actually have to go to bankruptcy court to get permission to continue with the eviction. That's routine. That's routinely granted, but that'll take a little bit of time, so it will slow down the process, which is good for the debtor and not good for the landlord. Now, with COVID, many areas of the country have issued moratoriums where you just cannot evict anyone. Here in Chicago, I live in one of the suburbs. The moratorium was extended until the end of January of 2021. So there are local differences there. So the basic answer to the question is the debtor will get the relief. The landlord has to wait a little bit. Eventually, they will be able to get the tenant out.
All right. It's that's a interesting time. So we'll see what happens with all of that. All right. The next question is someone who is looking for the proper terminology and ways to answer a case summons. It says in further detail, we were sued by a former landlord. In the process, we have filed for bankruptcy and debt is gone from us, but they are still trying to sue our cosigner. Court is next week and we want to file an answer. We are just trying to find the best way to file the answer to help out our cosigner. Joe, cosigning on things is something that we talked about several times. Again, especially with kids and parents and cars and different things, it can put someone in a whole heap of hot water.
Oh, it's such a no-no. Some people file bankruptcy only because they thought they did a good deed and co-signed for a family member. Usually it's for a child. So in this particular situation, the the thinking is good. It's a kind thing that they are trying to do, but they cannot help their cosigner in any fashion. They're okay. I'll get back to that. Assuming they filed a Chapter 7 bankruptcy and they were getting rid of their debt, it does not benefit the cosigner at all. They are off the hook because of the bankruptcy, but the cosigner is still responsible under the contract that was signed, which was the lease. So the cosigner will have to either make payment arrangements or file a bankruptcy, him or herself. Now, if this happened to be a Chapter 13, where you are paying back creditors in full or in part, Chapter 13 can also allow you to help your cosigner by paying back the cosigner debt 100%. So a little Chapter 13 tidbit thrown in there. Let me go back real quickly to the previous question about the landlord and the tenant filing bankruptcy. Bankruptcy is a wonderful law, but it doesn't allow you to live rent-free. You've got to pay your rent. Landlords entitled to their money. So you can get a short benefit by not getting evicted right away, but you're going to have to pay rent.
Well, and what happens when the person, a situation like right now where people can't be evicted until a certain amount of time, what you were talking about, what about the months of rent that are collecting? Are they going to be sued for that later?
They can be. I mean, it's a problem that's slowly building. The same thing with mortgages. Mortgage companies are allowing people to forbear their mortgage, make a forbearance agreement, meaning that we, the mortgage company, will forbear. We will not take action against you. We'll let you go 3, 4, 5, 6 months without paying. But the forbearance agreements I've seen make no provision about what happens with that past due money, and usually they're expecting it to come in one lump sum. So this is a problem that's building and is probably going to explode later this winter and next spring. And again, the landlord is entitled to their money. Nothing in there was a law enacted March 27th of this year, the CARES Act, dealing with financial assistance to businesses and people around the country because of the COVID virus. It also provided some changes in the bankruptcy laws, but it does not forgive the rent and mortgage that's due. So that's something we're gonna have to see what happens.
Yeah, it's gonna be interesting. Hope that 2021 is a better year, but before then, we have to keep on rolling here. Next question is, can I stop a wage garnishment if I currently do not have any income? The further detail on this question says that the garnishment started about a year ago, and I did not respond to the letter from the attorney acknowledging that I had received it. I worked 1 day last year, and they garnished that one paycheck. I currently receive food stamps as my only income and am living with friends. Can I file for bankruptcy to stop the garnishment before I find a new job?
So the simple answer is yes, and any garnishment issued now, or if it's ongoing, and that varies from state to state how those garnishments work, is rather meaningless because there's no income. So anytime a bankruptcy would be filed, whether it's now while this individual is not employed or once they start working, that bankruptcy will eliminate the debt, assuming it's Chapter 7, and prevent any further wage garnishments forever.
There are a lot of details going on with a lot of these questions, and there's so much that goes into the decision for someone to file for bankruptcy. And at Joseph Wrobel Limited, they're known for being Chicago's bankruptcy firm with experience, professionalism, and real concern for their clients. Because these bankruptcy laws are quite complicated, the procedures involved and the documentation required can be overwhelming, especially if you're not familiar with bankruptcy law. Joseph Wrobel has over 40 years of experience representing clients in consumer bankruptcy, and that experience ensures that your financial situation will be properly analyzed. At Joseph Wrobel Limited, he and his staff understand that you may be anxious about your financial problems and tired of being harassed by creditors. You're probably uncertain as to whether filing for bankruptcy is really what you need. If bankruptcy will help your financial situation, you will be properly advised for which chapter you may qualify. At Joseph Wrobel Limited, the entire procedure from beginning to end will be clearly explained to you, as well as the documents that you will need to provide. They will also present you with a comprehensive what to do next letter at or after your initial free consultation, and that will guide you through the entire process from start to finish. If you do not need to file, they will tell you. Joseph Wrobel Limited will not put you in a bankruptcy simply to earn a fee. Joseph Wrobel Limited is a small law firm of attorneys and staff experienced in consumer bankruptcy. They are not a large bankruptcy law factory, and you won't get lost in their office. You will be treated as a human being with courtesy, dignity, and respect. The mission of Joseph Wrobel Limited is to have you take control over your finances through the proper use of the bankruptcy laws. Joseph Wrobel Limited has offices located conveniently in the Chicago Loop, Chicago Rosemont, and in the suburbs of Burr Ridge, Deerfield, Gurnee, Naperville, Orland Park, Schaumburg, Skokie, St. Charles, and Westchester, so they can represent Illinois clients in Cook County, Will County, DuPage County, Kane County, LaSalle, Kendall, and Lake counties. All right, back to our program. We are talking next about foreclosure again. The question is, what can I do to protect myself from foreclosure? I'm currently $10,000 to $12,000 upside down in my mortgage due to the coronavirus. I was denied unemployment after waiting for several months for a resolution, but since I've gone back to work. I've put my house in forbearance for the last 6 to 9 months, but when contacted by the lender, their only solution was a lump sum payment due December 31st. I asked about repayment plans or attacking the amount due to the end of the principal, but they didn't offer me any options when I inquired. Why is my lender not providing me with any more options or details on a lump sum payment that I not be able to afford? I will have a good portion of it, but not the entire amount. What are my options to legally protect myself and my home when the time comes if they don't offer any other options as the lender?
Isn't it interesting how sometimes one question leads into another? We're dealing here with the forbearance with a large chunk of money that's due. So the caller poses a question: why won't the lender provide any other arrangements? They don't have to. He has an option of looking into a loan modification, which is a whole different process. But in the meantime, the payments that aren't being made, the balance increases and increases. Being employed, this person can protect him or herself with a Chapter 13 bankruptcy. Chapter 13 is a bankruptcy that people hear about and often shy away from, but has a tremendous value. It's particularly useful in a situation like this to either prevent a foreclosure from starting or from stopping a foreclosure that has already started. And again, foreclosure is the legal process that allows a mortgage company to take back someone's house through the court system. And what the Chapter 13 will allow to be done is that the past due money, these 9 months that are past due, can be repaid over a period of 5 years without having to negotiate with the mortgage company. At the same time, the regular monthly mortgage payments need to be made. Those will start again once the Chapter 13 is filed. We don't know the income situation. We don't know the expenses here, but assuming the income is sufficient to handle this person's monthly living expenses and there's money left over, the Chapter 13 could be an ideal solution to protect him or her from foreclosure.
I hope that more and more people learn about that as an option. Our next question also is about rent, but not a house. It's furniture. What recourse would a rent-to-own furniture store have if I file bankruptcy? Further, it says I've paid over half of my furniture and would have paid it all if I hadn't lost my job in the end of June due to COVID. They refuse to work with me and give me time or take smaller payments until it's straightened out so I can stop paying and file for bankruptcy and get them to leave me alone and not lose the furniture. I've already paid almost $2,000 when the cash price was only $700 to begin with. Yikes.
Well, what happens here is this is no different than a vehicle lease where at the end of the lease someone can own the vehicle, usually for a lump sum payment. Here at the end of the contract for renting the furniture, they become the owner of the furniture. If a bankruptcy is filed, it gives the debtor a lot of leverage with the finance company on the furniture. They don't want used furniture back, although they have a right to take it. And what generally will happen in a situation like this is once the bankruptcy is filed, they will work out a payment arrangement to make the payment smaller, usually reduce the balance. They will do that because they know the debtor could simply return the furniture and owe no money. And this is an example of a situation where filing such a bankruptcy without having an attorney is not a good thing, because doing this negotiation with the furniture company is something the bankruptcy attorneys are very well versed.
There you go. Like they say, you could file your own teeth and do your own dental work, but you'd probably rather see a dentist.
Yeah, it's a good point. Good point.
Yes. All right, our next one is about cars. We've talked about homes, furniture, and now we're talking about cars. They want to know if they can keep their car after filing for Chapter 7. They make payments through Capital One Auto Finance. They have a car worth $10,000, and they have $5,300 left on the loan balance. From what they understood, the equity is $4,700, and it says I've used my exemptions for $5,000. My lender hasn't asked me to reaffirm the loan. My questions are, does the loan get discharged, or should I approach the lender about reaffirming?
So here we go, another tie-in to the previous question. From the way this question is posed, I'm assuming this person filed their own bankruptcy without an attorney because they said my lender hasn't asked me to reaffirm. That's not how it works. After the bankruptcy is filed, it's your obligation to contact the lender and request a reaffirmation agreement. A reaffirmation agreement is an agreement that states that even though a bankruptcy is filed, you are choosing to keep your vehicle and make your payments. And lenders, in 99.99% of the circumstances, will always agree to do this. They make more money on the interest from your payments than on taking a vehicle back. So what this person needs to do here is to contact the lender, have them send out a reaffirmation agreement. The debtor has to complete it, sign it, and return it and get it filed with the court before the discharge is entered. If this is not done, the debtor is is in jeopardy of having the vehicle repossessed, even if they're making payments. vehicle loans need to be reaffirmed, and in addition to having payments made and keeping the vehicle insured.
Okay, good answer there. Again, they make more money in the interest than having a bunch of cars on a lot that are not selling anyways. I mean, right now, it's really one of those situations. There, I think about how many used cars. A lot of things aren't selling right now. People are very cautious, not only with COVID, but with the election issues and everything going on. People are holding tight and holding on right now. So it makes good sense to, as Joe said, get that reaffirmation done. Next one, we're talking about homes. We're talking about the future. When can I purchase a home after my Chapter 13 bankruptcy? I have several months left on my Chapter 13 bankruptcy. I was single when I filed. Now I'm married and I want to buy a home. How long do I have to wait to buy my first home?
There is no legal waiting period. There's nothing in the law that says you must wait a certain period of time in order to seek a mortgage and buy a home. Most lenders usually want to see 2 years since your bankruptcy has been completed. What have you done with credit? If you had a car loan that you reaffirmed, are you making payments? Are you paying your landlord? If you obtained a secured Visa or MasterCard, are you making payments on that? What is your income? What kind of job do you have? So the waiting period, it's not built into any law. It's just procedure with the lenders. Again, let me go back to that previous question on the reaffirmation. The reaffirmation agreements themselves are so non-intuitive. They're obviously a creation of bureaucracy, because if you look at it, it'll take quite some time to figure out how to complete it. So that's another example of why someone really should hire an attorney to help them with their bankruptcy.
We've talked about over the years so many situations where people will come back after they've done it themselves and they've got bigger problems than they had in the first place. Sometimes you really got to watch this stuff. It's not intuitive. You're right.
No, that's,
our next
that's
question
correct. I've had clients who've come to me because they did their own bankruptcy, and they wound up, it becomes more difficult sometimes to fix what they did than having it done right from the beginning.
Right, exactly. Same thing with our person who does their own dental work. I don't know, they might have a tooth pain and not too, but next question is, how much do you pay in a bankruptcy? I have a few $1,000s of savings, and I get a large medical bill like $50,000. I may have to declare bankruptcy. Would they take away the remaining savings I had, or would I not have to pay it? I really cannot afford health insurance right now, and I'm self-employed. Nothing has happened right now, but I just want to know what happens if something like that occurs.
Well, this again relates to something I said earlier, that one of the questions that are often asked at the initial interview, what happens to my home, my car, my savings, etc. People assume that they're going to lose what they own in a bankruptcy, and that can happen. So the answer to this question depends on the state in which this person lives and the amount of the exemption for cash or money in bank accounts that they're allowed to keep. And of course, we don't know the answer to that. But then if you have a situation where you have too much money in your savings and you would lose it if you filed Chapter 7, that would be a situation where a Chapter 13 would make sense. You could set up a payment plan to pay back part of the medical bill, wipe out the rest of it, and keep your savings.
There you go. All right, we have time for one more question, and it's again kind of comes back to the why you should have an attorney for all these issues. The question is, can I amend my bankruptcy petition after I had my meeting with the creditors, or my creditors meeting? It says, I forgot that someone co-signed on a student loan from me for 20 years ago. Can I add that information into my schedules? If after I already had my creditors meeting? That's the question. And what will it do to my case, if anything?
Well, what's funny about the term creditors meeting is that creditors rarely ever show up. They have a right to attend, but for most people, there's really nothing for the creditors to do. It terrifies people when they file bankruptcy, thinking they're going to have to face their creditors. That's one of the things we explain to them, that they really don't show up. The meeting is usually quite simple, questions asked by the trustee about assets. So this particular question, bankruptcy petitions can be very, amendments are liberally allowed. It's very easy to add something, to correct something if it was omitted or if there was a mistake. In this particular situation, leaving out the fact that there was a cosigner has absolutely no bearing on this individual's case. The trustee may or may not want them to correct it just to have a clear record, but this is a very almost inconsequential thing. But there are situations where the errors in a bankruptcy petition can come back to bite people, even with liberal amendments.
There you go. All right. So for those who are interested in bankruptcy, want more information, want to know if they might be a good candidate, and might want to learn more about that Chapter 13, what's the best way for them to get in touch with you?
Well, the best way is they can actually contact me directly. My cell phone is 312-804-8416. If someone doesn't really want to do that and they want to be a little anonymous, go to our website, chicagobankruptcy.com. We explain in quite good detail the basics of bankruptcy. People can get an idea of what's involved in both the Chapter 7 or Chapter 13 before they make an appointment. They can listen to previous question and answer programs like this one. They can watch some videos, and then they can put themselves in a situation where they have some understanding, then make an appointment to come in for a free consultation. And we are handling appointments right now at whatever is comfortable for the client. With COVID, we do them by telephone and email, by Zoom. We also do them in person, depending on the client's comfort level.
I tell you, there's one thing that we've gotten out of 2020 is more people having more options in how to conduct business. And I've heard from people all over the place how more comfortable the business and attorney-client situation has really become. And I think if I were you, I would put a big billboard along one of the interstates up there with your phone number and say, you can text me your bankruptcy question. Joe, they'll be texting you all night long.
You're right. You're right.
Your phone, ping, ping, ping. All right. There's going to be, I do predict that we have been through a test of so much this year, and we all are going to keep trucking and keep moving because the world is going to keep spinning. People are going to keep having new jobs, buying new things, having financial problems. I mean, bad things can happen to good people, and that's why Joe Wrobel's here to fix it. Joe, I appreciate your time. We'll talk to you next time.
Nick, thank you as always.
All right. Bye-bye now. Everyone have a great day.
Bye-bye.